You're, the only one ready is Jemiah Harris. It will be a plea instead of 10. I know
I have a jury trial next door.
Okay, so you want to plead it first?
It's gonna be a while, but no one else is here, so good.
Maybe everybody's on your
Sure. All right, this is the matter of State of Ohio versus Jemiah Harris, case number B 22044945. Ms. Harris is present in the courtroom with her attorney, Ms. Jody Gano, Mr. Nick Granke for the state of Ohio. This matter is set today for a jury trial, but it's my understanding the parties have reached an agreement, and I have been handed plea documents. Is that all accurate, Ms. Gano?
It is, Your Honor.
All right. Is that your understanding too, Ms. Harris?
Yes, ma'am.
Be that. Can you get Mr. B that? Are you the Jemiah Harris named in this indictment? Am I pronouncing your first name correctly?
Yes, ma'am.
Ms. Harris, how old are you?
29.
I can't hear you. Oh,
29.
29? And how far did you go in school?
9th grade.
Did you ever obtain your GED?
I got my high school diploma with job.
All right, so you do have your high school diploma.
Yes, ma'am.
And you're able to read and write the English language well?
Sort of.
Sort of. All right. What does that mean?
Yes.
You can read, you just don't read real well? Okay. Are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am.
All right. Ms. Harris, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Ms. Ganot's signature here, but right here, ma'am, is this your signature? Can you see that?
Yes, ma'am.
All right, is this your signature?
Yes, ma'am.
This is an acknowledgement by you that you understand that you have a constitutional right to have a trial, which is set for today. But when you sign this form, you're indicating to the court, I understand that, but I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after consulting with your attorney about your constitutional right to have a trial?
Yes, ma'am.
Do you have any questions about this form?
No.
Do you have any questions about your constitutional right to have a trial?
No, ma'am.
I also have in my hand a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. And at the top it says Agreed Sentence Plea. On the 3rd page, there are signatures. I recognize the prosecutor's signature here, Ms. Ganot's signature here, but up here, is this your signature where it says signature of defendant?
Yes, ma'am.
All right. Mr. Prosecutor, would you please put on the record the party's expectation regarding this plea?
Yes, Your Honor, this is a 3-count indictment. The state is expecting guilty pleas to 2 counts and would amend count 1, the rape, felony in the 1st degree, to gross sexual imposition of felony in the 4th degree. We're expecting a guilty plea to that count 1 and count 2, sexual battery, felony in the 3rd degree. In exchange, the state would move to dismiss count 3, Your Honor.
All right, thank you very much. Is that accurate, Ms. Ganot?
It is, Your Honor.
All right. And it's my understanding that there's an agreed recommendation by the parties on sentencing?
Correct.
All right,
That's 4 years.
all right. Is that accurate, Ms.?
It is, Your Honor.
All right. Ms. Harris, is that your understanding, what the prosecutor said?
Yes, ma'am.
All right. Are you under the influence of any medications, alcohol, or drugs today?
No, ma'am.
Do you now, or have you ever had to manage any type of mental health difficulties?
No, ma'am.
Are you presently under any type of probation or community control supervision in this or any other state?
No.
Probation.
No.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all other than the dismissal of count 3 if you enter guilty pleas to count 1 and 2, 1 being amended?
Yes.
All right, has anyone promised you anything other than that dismissal?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am.
Now, the state has indicated that you will be entering a guilty plea to 2 counts. Count 1 being reduced to gross sexual imposition, a felony of the 4th degree, and count 2 as charged, sexual battery, a felony of the 3rd degree. Is that what you talked with Ms. Ganot about before this hearing today?
Yes, ma'am.
Did you have an opportunity to review this 3-page plea form with Ms. Ganot before this hearing today?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Do you have any questions about it?
No, ma'am.
Did Ms. Ganot answer all of your questions about this plea form?
Yes, ma'am.
As you stand here now, do you have any questions?
No.
All right. Now, because it says agreed sentence plea, that alerts me that there's an agreement as to the parties on a recommendation of how I should sentence you. And I look on page 2, and the agreement between the parties is that when it all shakes out, that you would serve a total of 4 years in the Ohio Department of Corrections. Is that accurate?
Yes, ma'am.
Now, do you understand that while you and the state have presented to the court this sentencing recommendation. Do you understand that I don't have to accept it?
Yes, ma'am.
Now, I'm not indicating in any way right now that I won't accept it, but I need you to know that I don't have to accept it. I'm not obligated to accept your recommendation.
Yes, ma'am.
Knowing that I'm not obligated to accept the sentencing recommendation by the parties, do you still wish to go forward?
Yes, ma'am.
Now, Ms. Harris, do you believe you've had enough time to sufficiently consult with Ms. Gannot about your entire case before this hearing today?
Yes, ma'am.
Has your lawyer answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had enough time to review and or discuss the evidence that the state has against you with Ms. Gannot?
Yes, ma'am.
Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge?
To my knowledge, everything has been provided. Your Honor.
Ms. Gannot, do you acknowledge you see the same?
I can acknowledge that.
All right. Ms. Harris, are you satisfied with your attorney, Ms. Gannot?
Yes, ma'am.
Now, do you understand these charges against you? Count 1 being reduced from rape to a gross sexual imposition charge, a felony of the 4th degree. Do you understand that charge against you?
Yes, ma'am.
Do you understand the charge in count 2, sexual battery, a felony of the 3rd degree?
Yes, ma'am.
Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in those 2 counts, even as amended? Do you understand?
Yes, ma'am.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, knowing that count 1 is reduced to a felony of the 4th degree, do you understand that you are facing up to 18 months in prison and up to a maximum fine of $10,000 on that count?
Yes, ma'am.
Do you understand that as to count 2, sexual battery, a felony of the 3rd degree, that you are facing up to 36 months in prison and up to a $15,000 fine?
Yes, ma'am.
Do you understand that if I sentence you to prison upon your release from prison,
She shall be upheld.
well, because these are both felony sex offenses, the amount of post-release control time is mandatory, and it shall be 5 years. So I'm gonna just need you to amend that and talk to your client about it.
I apologize.
That's okay, you did complete the form correctly, I just needed to be amended last time.
You know, I said that I'm married, check a little bit. My store, I just want to make sure she's not. Ms. Jones, Jessica Jones.
It's the logo I just signed.
All right, Ms. Harris, Do you understand that if I sentence you to prison upon your release from prison, you shall be on post-release control for 5 years due to the nature of the offenses? Do you understand?
Yes, ma'am.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that?
Yes, ma'am.
Are you on post-release control right now?
No, ma'am.
Well, if you are on post-release control now, or even in the future, and you commit a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand?
Yes, ma'am.
I need to let you know that because these are felonies of the 3rd and 4th degree, community control is a possibility. Do you understand that I could place you on community control for up to 5 years instead of sending you to prison?
Yes, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service. Do you understand?
Yes, ma'am.
Do you have any questions so far?
No, ma'am.
When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand each of these rights as I've explained them?
Yes, ma'am.
Do you have any questions whatsoever about your constitutional rights?
No, ma'am.
Do you have any questions whatsoever about anything we've discussed today?
No, ma'am.
Do you understand that if you plead guilty, you are waiving all of these important constitutional rights?
Yes, ma'am.
Ms. Harris, knowing everything the court has discussed with you this morning, do you still wish to enter a guilty plea to count 1, reduced to gross sexual imposition, a felony of the 4th degree, and to count 2 as charged, sexual battery, a felony of the 3rd degree?
Yes, ma'am.
Counsel, is there anything further before I accept the plea?
No, Your Honor.
All right, may I hear a statement of facts?
Yes, Your Honor. The defendant on or about September 11, 2022 in Hamilton County, State of Ohio, engaged in sexual conduct to wit cunnilingus with JJ, who was not the spouse of the defendant or was the spouse of the defendant but was living separate and apart from the defendant, and the victim's ability to resist or consent was substantially impaired because of a mental or physical condition or because of advanced age. The defendant knew or had reasonable cause to believe that the victim's ability to resist or consent was substantially impaired because of a mental condition, physical condition, or because of advanced age. Your Honor, this count has been reduced to gross sexual imposition. Count 2, the defendant's same date, September 11th, 2022, Hamilton County, State of Ohio, purposely engaged in sexual conduct, again, cunnilingus with JJ, a person who was not the spouse at the time, and the defendant knew that the victim's ability to appraise the nature of or control her conduct was substantially impaired. Your Honor, this was known individuals, the victim and the defendant friends, who had a party together at certain points. This was at the victim's home. The victim retired to bed. She outright went to sleep at the house. I believe that everybody involved was drinking as that was part of the party. At certain points, the defendant snuck into the bedroom of the victim, who was asleep this entire time while the sex act was performed on the victim without her consent.
And you said the victim was impaired or had a disability?
She was impaired by the alcohol.
I see. All right. And the victim is an adult?
Correct.
All right, anything on the facts?
No, Your Honor.
Ms. Harris, did you, the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to count one, amended and reduced to gross sexual imposition, a felony of the fourth degree?
Guilty.
What is your plea to count two as charged, sexual battery, a felony of the third degree?
Guilty.
Let the record reflect that Jemiah Harris was present in court with her attorney, Ms. Jody Ganote, and that Ms. Harris was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Harris understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds Jemiah Harris guilty as to count one, reduced and amended to sexual battery, gross sexual imposition, a felony of the fourth degree in violation of revised code 2907.05 subsection 3. And guilty as to count two, sexual battery, a felony of the third degree in violation of revised code 2907.03 subsection A 3. Count 3 will be dismissed at the state's request. I'm sorry, wait a minute. Count 2 is subsection A2, not A3, as charged. Ms. Ganote, if you would mind making this amendment. Count 2, is that correct? Prosecutor, is count 2, subsection A2 of the revised
According
code?
to the indictment, yes, you are correct.
All right. Thank you. All right. Count 3 will be dismissed at the state's request. Is there any reason why sentence should not be imposed today?
Your Honor, we would ask for a period of time, a stay. Obviously, normally during a situation like an agreed entry, we don't normally ask for a PSI. We certainly could waive it because I know the state is acknowledging that my client does not have any criminal record. But asking the court to possibly consider it, as we would not want the court to order Ms. Harris to additional time than the 4 years that have been agreed. But to be quite candid with the court, we really are asking for a period of 30 days so that Ms. Harris, who has never been in trouble before, has always come to every court date, as the state is indicating, and sidebar has been here early on many occasions. If the court would please consider a period of 30 days so she can get her affairs in order, as she realizes she will be in the Department of Corrections for a significant period of time.
All right, thank you very much. State.
Your Honor, I conferred with the victim on this specific matter as we knew it was going to be asked. We would object for asking she be taken into custody today. There is concerns from the victim that she has contacts, I believe it was Mississippi or state down south, I believe in London knows there. There's concern from the victim that she may flee, but I will note that everything that Ms. Ganote said is accurate. This defendant has been here. I think I've seen her 4 times on separate dates. Typically beats me to court. She's here early the last 4 days I recall.
All right.
Your Honor, I have gotten absolutely no indication from her. I've spoken to her mother. She's here today for the plea, Your Honor. There's no chance that my client is going to flee. She's on an EMT.
Is Vicky?
She is not. She is. We've had communication the last 3 weeks while we're working out this plea. She has been great with communication. She did not wish to attend this. 4 years was agreed upon. She did state that she does want the EMD if the court would be inclined to grant this stay or PSI.
All right, thank you. All right, I think I need to, because of the nature of the offenses, order a victim impact. But I'm not gonna order a PSI, I don't think that's necessary. The victim impact can be done in a short period of time. I will continue this matter for sentencing. May 1st. May 1st, does that work for you, Ms. Benoit?
I have a jury started, but it should be fine.
All right, well, I can set it at 9,
45.
All right,
45, yes.
all right. Ms. Howard, let's set this up for sentencing on May 1st. And then, now, Ms. Harris, I'm expecting you to be back on May 1st. There is an agreed recommendation, so that means that you're asking the court to sentence you according to your agreement with the state. If you fail to appear, it won't happen, all right? And so I just want to encourage you, the EMD will stay on. Stay away from the victim will remain in effect, and then I'll see her back here on May 1st for sentencing. All right,
Thank you, Your Honor.
Thank you.
It's with Lizzie.
I gave her the papers. Well, you guys will keep up your side. No, we're gonna get one on him. I don't think we'll get it, sir. I didn't know. She asked me. I mean, they're, he's gonna go for your social just to. So. We can get some more time. Yeah, I mean, I think I could speak to it. Yeah, yeah. But since they're doing it for him. You want the victim impact? Yeah, I think she. Because we have to do it. Yeah.
Good morning.
I was here like that.
Are you, what is
Yes,
that?
I am I appreciate the offer.
This
It's my lady.
I'm about to call to see if I should move down again.
Okay, 'cause I got a 10 o'clock to do, so I was wondering if we should maybe, what do you have this morning?
This is the last thing I got going on.
Can we wait
What time do you usually get done with your Zoom call?
probably 20 after 10, I'm
You
guessing?
wanna come back and come back at 10:30? I mean, if that's okay, I don't want to ruin.
If we're doing them both at the same time,
You
I'm
don't
gonna,
have to do them both.
Yeah, but just, you don't. do them.
All right, who's next?
Well, sometimes
the do yours, Richard. Yeah, why don't you do yours?
I believe we call Armand Coates.
It all was.
All right, this is the matter of Armand Coates, case number B 22022972. Mr. Coates is present in the courtroom with his attorney, Mr. Kerry Neff, and Mr. Nick Gramke with the state of Ohio. This matter is on for probation violation hearing. And Mr. Neff, have you received a copy of the probation violation report?
We have.
All right, and does your client want a probable cause hearing?
No, Your Honor, we would concede or waive probable cause, specifically for the following reason. Count one, or excuse me, rule one, involves a new charge. He has checked the records, he's actually been indicted already on a new charge. carrying a concealed weapon. It's B-23-01348. That case is coming before Your Honor with DSC on April 21st.
All right,
So that would constitute probable cause. With the court's permission, I would suggest that it makes sense to continue this probation violation to match up with the new case. That would, I think the 21st is Friday or Thursday.
all right.
And his attorney on that case is Anna Castellini. So I'm happy to stay on this case, or if the court thinks it's more efficient to have a new attorney, or that felony, or combine it into one case, that would be fine with me.
So, he does not want to enter a plea, just want to continue the whole
I think
thing?
that would make sense.
All right.
Yeah. So we'll concede probable cause because he has been indicted and charged, but as far as the plea in any sense, it would make sense to wait until the case.
All right. Let's, continue, probation violation, Ms. Allen. Just give me another date, and the other case will be in front of me.
April 21st.
421,
Yes.
this Friday.
This is DSC.
Why don't we schedule it out so that the DSC, because we're not gonna have a probation violation with DSC. We just schedule DSC out so it wasn't gonna be probation violation. You know what I'm saying?
May 17th.
Wednesday the 17th, it's fine, May 17th.
All right, May 17th for this. At 9, and then the other case will catch up to this. Now, young man, let me tell you something. You already have a probation violation. You have a new charge. Between now, which is April 17th and May 17th, don't come back here with another charge or a new probation violation. You understand? Does he have an EMD on?
He does, Your Honor, apparently that's an additional release on the new felony.
All right.
Mr. Mellon. Mr. Mellon.
Well, good, because I'm gonna, make sure it stays on this case as well. So even if Judge Mallory takes you off, you're still on, because I just put you on, understand? All right, you have any questions? Okay. All right.
That's Judge.
All right, we'll see you on, May 17th. All right, who's next?
I think my guy's coming down.
Who's that?
It's Mr. Roden.
Okay, we're gonna do both. Let's get a co-defendant.
Yeah, but I think Mr. Nye had to run to a Zoom conference and he's coming back at like 10:20 to do that. If you wanted to do them together, I can come back. We didn't know.
Are they both entering pleas then?
Yeah, but my client has to do an agreed and Darren's client does not based on records and offers from the state. So it's a little bit different. I don't know how you want to handle that.
I think I could do. A minute before you vote in here. Okay. So I can't do either one of them right now. There'll be a second for the.
That's fine. Did you want them together or not?
It's easier on me.
Well, that's fine. I can come back if you would prefer that to do so.
No, he's on his way down, right?
Okay.
But they just have to do a shift change, so. Okay. If he comes down first, we'll just go ahead and take care of it.
That's fine, Judge. Thank you. That's fine.
It's just easier if you do one plea, as opposed to doing that whole thing twice. Everybody else. Christmas.
So where are we? 12 years?
I think that's where we let go. I'm gonna talk to him.
Mr. Magnus, are you ready?
Your Honor, I need an affidavit of indigency for my client.
All right, can you be heard to get that done? 'Cause I need to.
think we're ready, yeah.
I think we're ready,
Put
Judge.
your client down.
That's okay, Your Honor. I'm gonna run up and talk to him right after.
All right.
Mr. Riley spoke with him on Friday.
All right, this is the matter of State of Ohio versus Embryo Terry, case number B 2105820. Mr. Connor Riley and Mr. John Duhan present on behalf of Embryo Terry and Ms. Colson on behalf of the State of Ohio. Magnus, affidavit of agency, so I can go right for this case to the next one. All right, this matter is set for a plea or trial setting, and what's the status?
Your Honor, I understand this case is quite old at this point, but it is new to me. I was just recently appointed. This is my first appearance on the case, replacing Attorney Bernard Mundy. I can get up to speed very quickly on this, Judge, but I would ask the court to consider giving one final clear trial setting so I can be fully up to speed with the amount of discovery in this case. By that next setting, I'll be prepared to set the case for jury or plea, depending on what Mr. Terry wants to do.
All right, thank you very much. So let's set first let's set the jury trial. Then we'll go back and set a retrial. All right.
I'm just getting my calendar done.
Thank you. How long do you think this case will take?
To try? Is that what you're, okay, the trial? I think it will take, at least a week and probably bleed over into the next week.
All right. That's your assessment too, Mr. Duhon?
I'm not sure how many witnesses the state has yet, but based on, I trust her, representation.
How about June 12th? How's that look?
I am not available that day, Judge. I have 2 other trials.
Older?
I believe at least one is. I'm not sure, I don't have the numbers, but.
Well, Your Honor, I'll note that if it worked for everyone, I am out of town the 16th, which is Friday of that week. But I'm returning that Sunday.
Yeah. June.
I have another trial set that day, Judge.
All right. Why don't we start with when you don't have a trial?
The first day I am available is July 31st.
July what?
31st.
Oh, yeah. That's my.
I am out of town that
So, what about July 5th? I mean, June 5th? I'm sorry, June 5th?
I could make that work.
Duhon,
I'm available.
Mr. Paulson?
I am not available, I have another trial set that day.
Is it older and is the person incarcerated?
I believe the person is incarcerated, I don't have the number, I'm not sure if it's her or not. Javante Dixon.
Who's his name?
I do not, Javante Dixon, it's J-A-U-N-D-I-X. D is in dinosaur, I-X. TV, I believe. Yes. Yes.
What's the case number?
County 2201473.
It is not.
Yeah, that case is a 22 case, this case is a 21 case, so June 5th,
Your Honor, the only question I have, I don't have the duty judge scheduled that far off. Are you the duty judge the week before May 27th?
before May 27th.
No, the week of May 27th. Or I guess it'd be, looks like May 29th.
No,
Okay, I just didn't want to, we have to do the hearing with the duty judge the week prior. I just didn't want to come
yeah,
and have that be you.
I appreciate it. All right, yeah, June 5th is a trial, and then Ms. Howard, can we just get a pretrial now, do you want a final pretrial conference again? Because Mr.
I would appreciate it, Your Honor. Meeting goes on Wednesdays,
Thursdays.
Thursdays. Perhaps, I'll be in trial if we do it early, it'd be okay, I could be May 25th.
Yeah, May 25th or May 18th.
I'm gone the 18th, but we have a trial date that I could call it.
No, maybe 25th would be fine.
All right. Final pretrial, May 25th, 9 o'clock. And then let's just, give a, you want a pretrial as well, the status in the next month or so?
I don't see the necessity for that.
Don't need that? All right. Ms. Poston, what about you? You all right?
Yes, Judge.
All right. So we have a jury trial set June 5th at 10 a.m. and a final pretrial conference set May 25th at 9 a.m. All right?
Thank you,
All
Judge.
right.
Thank you very much.
Time wait till then?
Yes, Your Honor.
Thank you. Mr. Magnus, you ready?
Yes, Your Honor.
This is a matter of State of Ohio versus Elijah Israel. Case number E2205662. Mr. Israel is present in the courtroom with his attorney, Mr. Richard Magnus, and Mr. Nick Granke from the state of Ohio. This matter is set for a sentencing with Mr. Israel entering a guilty plea on March 15, 2023, to count 1, trafficking of cocaine, a felony of the 3rd degree, and possession of cocaine, a felony of the 3rd degree. All remaining counts being requested to be dismissed at the state's request. A PSI was ordered, the court has received it, as well as a mitigation of sentence report. Mr. Magnus, have you received a copy?
I have 2 copies of each, Your Honor.
All right, would you like to say on behalf of Mr. Israel?
Your Honor, he's now 22 years old. Early in this case, he did do 8 days of incarceration. He is here today. He's looking a little odd to you. He informs me he's got conjunctivitis in one of his eyes. So we apologize for that appearance. I don't think that should affect the sentencing any, but I want to at least alert the court. He's got a drug problem. He is not in the least bit of denial that he's got a drug problem. And it sure looks to me, everything about him says we deal with the drug problem, we can make his life go well. If we don't deal with the drug problem, we're just gonna have similar cycles happen over and over again. Finally, Judge, I will note, I do believe these 2 counts would merge for sentencing, since it's basically possession and possession with intent to distribute. So we would ask for 1 sentence, not 2. I believe that a term of probation, would be appropriate with drug treatment as the primary condition of probation.
All right, thank you very much. State?
Your Honor, ultimately, I would defer to Your Honor. I'm looking at, I reviewed the documents given today. I think these are that a real crossroads, whether or not the state can step in and help at any time. I don't know if this is all personal use. Some of the issues with the probation violation we all heard weeks ago, his activity. I am concerned that this probationary period will be a waste of time, waste of money for everybody. But given the nature of the charges, I would defer to the court in this sentence. Thank you.
Mr. Israel, am I pronouncing your name right? I think I'm not.
Israel, that's one.
Israel.
One
All
outside.
right. What would you like to say before I pass sentence?
I had it written down, but I put it on my phone.
All right, why don't you step up to the mic so I can hear you clearly?
Dear Judge Cross, Dear Judge Cross, I am writing this letter on behalf of myself. If you do choose to grant me probation, I promise I'm not going to waste a second chance at freedom you are giving me. You won't see me anymore in your courtroom, and also I have a daughter about to be born August 1st. I really want to be here to see her be born, and I also have potential to be a better man for my family. I'm ready to take accountability for my actions and make positive changes for myself.
And how are you gonna do that?
Going to trying to, like my attorney said, I'm trying to work on my drug problem.
In what way? How are you doing that?
I'm really just, I went to an NA class, like an NA class.
What was that?
That was before I took the boxing years. It was like when I first brought it out, he told me to go to an NA class. I forgot what time. It was like around like December. It was like January or December. I went to an NA class. I'm really trying to just like be better.
How?
I don't want to do drugs anymore. I don't.
Look, young man, you're 22 years old. You've been in prison twice.
No, I've been one time.
You've been once?
Yes,
Oh,
it's one time.
yes, I said,
There were multiple offenses, Judge, with concurrent sentences.
yeah, okay. You say December 1st, 2021, you were sentenced to 18 months under one case number. And then I have another, it says on March 22nd, 2021, he was sentenced for another case number. You see that in the PSI?
It's two separate cases. It was two separate ones.
But you only went to prison one time?
Yeah, they brought me back here and then they brought me back down here to court from prison.
Got it. So you were in prison, they brought you back down and sent you back to prison?
Yes.
Oh, okay, so, okay, I understand. That we consider that too, but I understand you were already in prison. This is the thing. You can't wish a drug problem away. Nor can you, I'm trying. You can't just say it and it be so. You cannot wish it and it be so.
I'm just asking for a chance.
I know what you're asking for. I'm going off of what you just said. You said, I'm trying to be a better man. Did you say that?
Yeah.
He said, I'm just trying to.
Yeah, like getting a job and changing. I've been working a job, but like keeping the job. I've been trying.
Okay, hold on. So I was quiet when you talked. Now you're gonna be quiet when I talk. Okay?
I'm sorry.
That's okay. So, what I'm trying to get you to understand is that trying is an action word. That means you have to be doing something. Not thinking it, not wishing it, but doing. And so when I asked you real simply, what are you doing? You said, I'm trying to be a better man. I said, what are you doing? You just looked at me. When you said, well, I'm trying to, just want to kick this habit. I said, well, what are you doing? You said, well, I'm trying. But you haven't given me any evidence, any effort. That's what trying means, effort. Do you understand? Do you understand that?
Yes, ma'am.
All right. So if you're not going to put any effort behind it, then just don't say the words trying. Because it means nothing. Okay? I want to help you with that. Because I think a lot of times people think they're doing something and they're doing nothing. Just because they say they're trying. So what I want to see is you actually try. I want to see you actually put some effort behind the words. Because you can't just come in here and just tell me anything. Now, I'm willing to give you a chance to show me that you're going to put some effort behind this. But if you don't, we're not going to have another conversation. You understand?
Yes, ma'am.
The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the recidivism factors and seriousness factors as set forth in revised code 2929.12. Accordingly, I hereby sentence you to a term of 3 years of intensive community control, intensive supervision, because we're going to see if you try. Mr. Magnus, I see there's an affidavit of indigency, but the PSI said he's working at Rumpke.
He is working, Your Honor. It is a very low-wage job. I do not believe he can come up with the mandatory fine, which I don't believe the court has the right to defer. Obviously, if the court wishes to give him a discretionary fine, you can make a fine of indigency and still fine him, but it gives the court more options.
All right. All right. I will accept the affidavit of indigency. And remit the fine and costs. Now, young man, you're going to do some kind of treatment program, outpatient drug treatment program, as recommended by probation. Do you understand?
Yes, ma'am.
I don't want to hear any excuses. Why you program or get to the appointment or I had to do this. I don't want to hear that. Just do what you're supposed to do. If you violate the terms of community control, I will not hesitate to sentence you to a term of 36 months in the Ohio Department of Corrections. You understand?
Yes, ma'am.
And, you have the box on now?
Yes.
I'm gonna terminate the EMD. Anything else, Mr. Magnus?
Nothing, Your Honor.
State?
No, Your Honor, thank you.
All right, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. You understand?
Yes, ma'am.
Now, Mr. Israel, I'm putting in notes of our discussion today, and you trying.
Yeah, I'm not gonna mess up.
All right, so that if you come back on a probation violation, I'm gonna know that you just didn't try. Okay? All right, but if you do well, I will consider releasing you from probation early. We'll see.
Thank you.
It's up to you. All right, anything else? All right, you have to go to probation, today. Right at the court. All right, thank you.
May I assume you don't want to appeal?
Thank you.
This one, appreciate that. No, this was
It's just straight down to you. That's that.
What's that?
That.
Thanks.
All right, this is the matter of State of Ohio versus William Roden, case number B2300169B. Mr. Roden is present in the courtroom with his attorney, Mr. File, Mr. Ramke for the State of Ohio. This matter is set for jury trial today, but it's my understanding the parties have reached an agreement and I've been handed plea documents. Is that how your client wishes to proceed, Mr. File?
It is, Your Honor.
Is that accurate, Mr. Roden?
Yes, ma'am.
All right. Are you the William Roden named in this indictment?
Yes,
How old are you, Mr. Roden?
30.
How far did you go in school?
I got my GED.
All right, so you're able to read and write the English language well?
Yes, ma'am.
Have you ever served in the military?
No.
Are you a U.S. citizen?
Yes.
Mr. Roden, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. File's signature here, but up here, sir, right above where it says defendant, is this your signature?
Yes.
Can you see it all right here?
Yes.
This is an acknowledgement by you that you understand you have a constitutional right to have a trial. But when you sign this form, you're indicating to the court, I I understand that, but I'm waiving my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes.
Did you sign this form after consulting with Mr. File about your constitutional right to a trial?
Yes.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to a trial?
No, ma'am.
I also have in my hand, Mr. Roden, a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize the prosecutor's signature here, Mr. File's signature here, but up here, where it says signature of defendant, is that your signature?
Yes.
Can you see it all right from there?
Yes.
All right. Now, this is a document that up here it says agreed sentence plea. That alerts the court that there is an agreement between the parties on a sentencing recommendation to the court. Is that your understanding as well?
Yes, ma'am.
All right. Mr. Prosecutor, would you please put on the record the party's expectation regarding the plea?
Yes, Your Honor, thank you. Your Honor, this is a 9-count indictment. However, the defendant, William Roden, is one associated with count 3 and count 4. Count 3 is aggravated burglary, felony in the 1st degree. Count 4 is felonious assault, felony in the 2nd degree. Your Honor, we are asking for a guilty plea to count 3 reduced to a felony in the 3rd degree burglary, and count 4 reduced to an aggravated assault, felony in the 4th degree.
All right. Mr. File, is that accurate?
Yes, it is, Your Honor.
Mr. Roden, is that your understanding of what you would be pleading to?
Yes, ma'am.
All right. Are you under the influence of any medications, alcohol, or drugs today?
No, ma'am.
Do you now or have you ever had to manage any type of mental health difficulties?
No.
Are you presently under any type of probation or community control supervision in this state or any other state?
No.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all if you enter into this guilty plea today?
No.
Are you making this plea of your own free will?
Yes.
Now, the state has indicated that you would be entering a guilty plea to 2 counts of the indictment, the 2 that you're charged in, count 3 and count 4, and that count 3 is being reduced and amended from aggravated burglary, felony in the 1st degree, down to burglary, a felony in the 3rd degree. Is that your understanding?
Yes.
And that count 4 is being reduced from felonious assault, a felony in the 2nd degree, to an aggravated assault, a felony in the 4th degree. Is that your understanding?
Yes.
Now, is that what you talked with Mr. File about before this hearing today?
Yes, ma'am.
Have you had an opportunity to review this 3-page plea form with your attorney before this hearing today?
Yes.
And do you understand what it says?
Yes, ma'am.
Do you have any questions about it today?
No, ma'am.
Did your attorney answer all of your questions about the plea form?
Yes, ma'am.
Do you understand that while you and the state have an agreement to make a recommendation to the court on sentencing, that the court doesn't have to accept that recommendation?
Yes, ma'am.
I'm not indicating at this point that I will not, but I need you to understand that the court is not obligated to accept the sentencing recommendation. Do you understand?
Yes, ma'am.
Knowing that the court is not obligated to accept the sentencing recommendation, do you still wish to go forward with this plea?
Yes, ma'am.
Now, Mr. Roden, do you believe you've had enough time to sufficiently consult with your attorney about this plea and about your entire case before this hearing today?
Yes, ma'am.
Has your lawyer answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to review and or discuss the evidence that the state has against you with your attorney?
Yes, ma'am.
Mr. Prosecutor, would you please put on the record whether or not the state is providing all discovery evidence, including any Brady material evidence, if any, to your knowledge?
To my knowledge, everything has been provided, Your Honor. I know that there was talk about the BWC being missing, but that was sent last minute. I don't know if the council got that.
I got it. However, Judge, it does not relate to Mr. Rhodes' case directly. It relates to the co-defendant's case for the charges that are beyond count 5 and beyond, primarily interviews. Mr. Rhodes is primarily the only charge with counts 3 and 4, which we had all the evidence prior to the day. Some of it was marked on Rule 16, and as a result of the state's consent to allow Mr. Rhodes to review some criminal 16 motion materials, we entered into this plea agreement.
All right, thank you very much. Mr. Roden, are you satisfied with your attorney, Mr. File?
Yes, ma'am.
Now, do you understand these amended and reduced charges against you in count 3 and 4? Count 3 being burglary, a felony of the 3rd degree, and count 4 being aggravated assault, a felony of the 4th degree.
Yes.
Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in those reduced and amended charges?
Yes, ma'am.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, count 3 being a felony of the 3rd degree, do you understand that you're facing up to 36 months in prison and up to a maximum fine of $10,000?
Yes, ma'am.
And do you understand that as to count 4, since it's a felony of the 4th degree, that you're facing up to 18 months in prison and up to a maximum fine of $5,000?
Yes, ma'am.
Do you understand that if I sentence you to prison, upon release from prison, you could be on post-release control for up to 2 years? Do you understand?
Yes, ma'am.
All right, Mr. File, you completed this form correctly, but would you mind specifying in the PRC column 2 years, up to 2
I
years?
can't, Judge, I think we just got May on there, so.
Up to 2 years.
Mr. Roden, that says on the right-hand margin, it says for count 3 is up to 2 years and count 4 represents up to 2 years of post-release control. That understanding now?
Yes, but it's not mandatory.
It's not mandatory, it's May.
All right. So, Mr. File, I just observed him here in court documenting the first page of the plea form with what I just notified you, that this is discretionary post-release control up to 2 years. Do you understand that?
Yes, ma'am.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes, ma'am.
Are you on post-release control right now?
No, ma'am.
Well, do you understand that if you are convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time, or whichever is greater. Do you understand that?
Yes, ma'am.
All right. Now, I know this is a agreed sentence recommendation, but because you're pleading guilty to felony 3 and felony 4, community control is a possibility. Do you understand that I could place you on community control for up to 5 years instead of sending you to prison?
Yes, ma'am.
Also, I could, if I impose court costs and you fail to pay those court costs, I could order you to do community service. Do you understand that?
Yes, ma'am.
Do you have any questions so far, Mr. Roden?
No, ma'am.
When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial either to the court or to a jury of 12 persons, which was set for today?
Yes, ma'am.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand each of these rights as I've explained them?
Yes, ma'am.
Do you have any questions whatsoever about your constitutional rights?
No, ma'am.
Do you have any questions about anything we've discussed today?
No, ma'am.
Do Do you understand that if you plead guilty, you are giving up or waiving all of these important constitutional rights?
Yes, ma'am.
Mr. Roden, knowing everything the court has discussed with you, do you still wish to enter a guilty plea as amended and reduced in count 3 and count 4 to burglary and aggravated assault?
Yes, ma'am.
Counsel, is there anything further before I accept the pleas?
No, Your Honor.
All right, may I hear a statement of facts?
Yes, Your Honor. William Roden on or about January 9th, 2023, in Hamilton County, State of Ohio, by force, stealth, or deception, trespass in an occupied structure or a separately secured or separately occupied portion of occupied structure when another person other than the accomplice of the defendant was present with purpose to commit in the structure or in the separately secured or separately occupied portion of the structure a criminal offense at the time the defendant recklessly inflicted, attempted to inflict, or threatened to inflict physical harm on Michael Prismer, violation 2911.11A1. Your Honor, this charge has been amended to the F3 burglary. That statute reading was for aggravated burglary F1. We'll get into the facts of why that was done after I read the second counts. William Roden on or about January 9th, 2023, in Hamilton County, State of Ohio, knowingly caused serious physical harm to Michael Prismer in violation of 2903.11A1. This has been reduced to the aggravated burglary. Your Honor, the facts of this case are simply
Or aggravated assault?
aggravated assault. What did I say?
Aggravated burglary.
Thank you.
All right.
Aggravated assault. Mr. Roden with a co-defendant walked up to a house. It was vacant at the time. Obviously, someone lived there. There was nothing that it was vacant, but they broke in when no one was present. The homeowners then drove up on them in the house and approached knowing that someone was involved or inside their house. A scuffle ensued where one of the homeowners got seriously injured by a rock and some other fists happened during the fight. They were essentially detained by the home residents, and officers quickly arrived on scene and apprehended Mr. Roden and the co-defendant outside the property.
All right, thank you very much. Anything on those facts?
Just that, as they were charged, Your Honor, we evaluated, I believe that legally the charge had to be reduced, but just so factually you are aware, they are not disputing he entered the home. The issue is that any physical confrontation occurred outside of the home, was in the front yard of the homeowner. And Mr. Green is correct, is that Mr. Roden was, actually, he was sat on by the homeowner, Mr. Christopher, to the police came. It took approximately 10 minutes for them to arrive. The co-defendant in this case, Mr. Roden, was very concerned as to what was going on with her. There was video that would demonstrate everything in this case preceding the trial. He basically was concerned about her at the time, and he just wanted the court to be aware that he did not have the intent to cause any harm in the home. He did not have the intent to cause any harm to the homeowner. Unfortunately, he could not move, and his co-defendant was engaged in an altercation on video with the other homeowner, with the female homeowner.
So are you saying I shouldn't accept the aggravated assault?
No, I think that the aggravated assault is the appropriate charge. When it was a felonious assault, the charge indicated that he had a lot of thought in what was going on. He did not. It was a matter of him being apprehended in the homeowner's own property in their yard outside.
But there was a scuffle that he was
Oh,
involved
yeah,
in.
it's clearly there was a lot of things going on. It was on the video surveillance that was providing discovery for cheese observed.
All right. Mr. Roden, did you hear what the prosecutor said that you did?
Yes, ma'am.
And your attorney explained some of it?
Yes, ma'am.
Is it all true?
Yes, ma'am.
What is your plea to count 3, burglary, a felony of the 3rd degree?
Guilty.
And what is your plea to aggravated assault, a felony of the 4th degree?
Guilty.
Let the record reflect that Mr. William Roden was present in court with his attorney, Mr. Richard File, and that Mr. Roden was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Roden understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds William Roden guilty as to count 3, burglary, a felony of the 3rd degree, in violation of Revised Code 2911.12, subsection A3, and finding his guilty plea to be voluntary as to count 4, the court accepts that guilty plea and finds William Roden guilty as to count 4, amended and reduced to aggravated assault, a felony of the 4th degree, in violation of Revised Code 2903.12, subsection A1. There are no counts in the indictment against Mr. Roden to dismiss. Is there any reason why a sentence should not be entered today?
Well, we were kind of questioning that, when this plea was, worked out, the state has indicated that they are not asking for a pre-sentence investigation, and we thought that the court would be on its own requesting a victim impact statement based on the nature of the charge as indicted. However, if the court does not need one, Mr. Roden is fully aware that the court could proceed today and would be satisfied in that regard. We just didn't know if the court wanted one.
Well, I don't have to get a PSI for this agreed sentence, but I would like a victim impact statement.
So that's, he is aware that we did not know that was going to be the case, but if the court needs that, he's fully aware that he does want the court to be aware that in the interim, since we've been working on this case, both of his parents have been suffering some heart and problems, and they are in custody of his 10-year-old daughter. He asked me if the court was going to continue this case and not sentence today, if he may have an opportunity to spend some time with his family before he leaves. But I told him that's at the court's discretion if they were going to continue the case for 7 days.
All right, State?
Your Honor, I would strongly oppose to stay or release at this time. He has limited offenses that are very serious. He also has a very strong and serious record. So I would oppose to any release at this time.
All right, Ms. Howard, when can we do the sentencing?
May 17th.
Judge, I'm in your courtroom on that day anyways.
All right, we'll do sentencing May 17th at 9 a.m. Request for release or stay is denied. All right, we'll see you back here on May 17th.
Thank you, Your Honor. Right, I will.
All right, who's next?
Mr. Ewing is next.
Mr. Ewing?
Juan.
Harold? Good morning. All right, this matter, State of Ohio versus Devon Harrell, case number B2205-295. Mr. Harrell's present in the courtroom, his attorney, Mr. Tom Ewing, Mr. Granke for the state of Ohio. This matter is set for jury trial today. Mr. Is the state ready?
The state is not ready to proceed, Your Honor. The victim did not appear in court.
Oh, okay.
Your Honor, so for the record, we're maintaining our non-guilty plea, and we're asking for dismissal of the matter. Mr. Granke has made extensive efforts to try to reach out to the state's witness, and she has been non-responsive the entire time. We subpoenaed her to our final pretrial date. She did not come. He was trying to reach her via a number of electronic means, and she has been non-responsive. She's not here.
Is all of that accurate, Mr. Granke?
That is accurate, Your Honor. I'd like to expand on it just a little bit as well. And unfortunately, I don't think I can in good faith ask for a continuance on this matter. I did everything that Mr. Ewing said. She was subpoenaed at the last setting, subpoenaed today. I actually had the officer who was present today. He left a short time ago. But he was actually at the house twice last week. One time he said he certainly heard someone home. However, no one approached. He left a letter at that time. He went back the next day to even do further investigation. And no one, again, he heard some stuff, but no one appeared at the door. There's been contact with, I think it's an advocate, where she was able to get someone on the other line who was then quickly told her not to call and would hang up. So at this time, the state has gone through many, many means to get this individual to appear in courts. At this time, I cannot ask for anything else.
All right, this matter is dismissed for want of prosecution. Does he have any type of GPS or monitoring?
He's just been out.
All right, this matter is dismissed for want of prosecution.
Thank you very much.
Thank you.
Miley, okay. Great.
Who's coming down next? Yeah, I think they still do the code fence, yeah, because it's just easy for me to say all that one time. All right, where's Mr. Baker?
He just stepped out.
Are we ready on that one?
We're going to be in the same posture the state will be.
Okay, Mr. Davis here. Okay, he is. You all have been sitting here for a while. Who are you for? Danny. Mr. Davis, okay, thank you. So, who's next? Oh. I'd rather bring Mr. Davis down. Where's Mr. Baker? I'd rather bring Mr. Davis down. Let's go ahead and, hold on, nice.
Hey, this is Lauren, Judge Cross's book. It's hoping to speak. Oh, it's already perfect.
Taxes are due today.
Sorry.
Is it tomorrow?
Perfect.
All right.
Those are by phone anyway, so call
That
them.
just makes me feel better, 'cause I called my accountant, like, do I still have time to put money in my?
I'm sorry, the, that's separate Wednesday, that's gonna be by phone anyway.
What's today's date? Okay, so it is 18th, okay, all right. I don't know why.
Nice, same things.
All right.
I'm gonna ask for Victor impact. I don't know if they want
All right. Driving in this morning. He usually always does file.
Oh, okay.
That's more stuff that later, you know, and then it's one of those situations where they're scrambling trying to figure it out.
Mr. Baker, your client's on the way down.
Oh, thank you, Judge.
Do you want a nice rest of your day?
Sure got lots of too.
Yeah, yes, I see.
Well, no, a lot less pressure than he's literally right after they got it. I mean, they were in there for about a minute. The lady
Mr. Neff, you have, Mr. Howell.
I do, Your Honor.
Okay.
Judge, I just give you an update. He is locked up. This is the gentleman who has misdemeanor. He's serving his sentence in front of Judge Bennett. I did talk to John. My client had called me, I think Friday or Saturday, and said that Josh Evans, his attorney in that case, was filing a motion to mitigate.
Okay.
We haven't put it to the cast for jumping. My client asked me to. So my client will be wanting me to ask you for continuance on this case to see if we can mitigate this misdemeanor.
Okay.
It takes up anything, this court when they're sentenced.
Okay. I'll see you. That's okay. I just wanted to. Mr. Neff, do you know when,
I did check his motion to mitigate is up on the 20th, so it's Thursday.
okay.
That's all. That was your question.
Yeah, that's what I was gonna ask.
And I did confirm that. I know this call, but
Okay, so why don't we just, we want to continue this till after then?
that's what he's asking.
All right, Mr. Granke, I know you were here in the courtroom, but you might not have heard everything. Mr. Howell is asking to continue the probation violation hearing until after his misdemeanor motion to mitigate. Because he's asking for a certain program, and he's hoping that if he gets it, I'll do the same. What's your thought on that?
I'm okay with whatever he wants, but I know we're worried about which judge is gonna make the decision first. That better might say the same, same thing, so.
Yeah.
This is what he wants, that's fine.
Okay. We can continue it to after the 20th? Or on the 20th?
So Sunday after the 20th.
All right. Ms. Howard.
I think Friday is.
Can't do Friday.
Bad day for me, so we go to next week. Friday. Monday versus Wednesday.
You know, any-
You had a letter from the city, they provided Mr. Alvarez acceptance in the city. So, if Mr. Alvarez litigated and doing taxes for grant, like, higher taxes, and this work is something to consider. Thank you.
All right, thank you.
Anything else? Thank you.
Done. Here's just a dismissal. Why that's for dismissal?
Right, I was thinking some more times, but-
Phone number, address.
Well, I see it suggested. They want to do Alan, but I could say.
I am too. Well, that's, I had 2 days last week where I did that Wednesday night, Thursday night, where I worked on coordinating and just football nights. It drives me crazy. And then you come in on a day like today where it's dreary out, and you're like, dragging.
It's not a beautiful day where they're working.
That's true. That is true. You got anything good otherwise on? You get Trish playing or anything?
That I do. Turks and Caicos.
Where's that at?
Fairly close to Germany.
What nationality is, for what country? Type in St.
All right, Mr. Davis is on his way down, but can we, just have a discussion on what's going on with this? Set the trial today. We'll reiterate all of this when he, gets down. So this is separate trial. Who is ready?
State county,
The state is not ready, or we're not?
victim is not present here. I don't know the full circumstances of his living ability, but it does seem like it's a little vagrant. The officer saw the house that was listed, it is now a vacant apartment. However, the officer saw this individual on the streets. I believe the officer said here that last week he saw him. That's correct, sir. Okay, so we just don't have the communication. I think it's mainly because of the lifestyle the victim lived, not suffering. It's had multiple numbers, so we are as a continuance. We do think that there's a chance we can find some.
All right, let's let him bring Mr. Davis over because we're talking about his case now anyway. This is the matter of State of Ohio versus Danny Davis, case number B2300111. Mr. Davis is present in the courtroom with his attorney, Mr. Red Baker, and Mr. Nick Gramke for the State of Ohio. So this matter is set for jury trial today, and it's my understanding the state is requesting a continuance. Can you put on the record why, Mr. Gramke?
Yeah, sure. So we have done the typical thing, which is send out a subpoena and make phone calls. However, this individual, the officer went to that subpoena location, and that building is now vacant, no one lives there. We have multiple cell phone numbers for this individual, so I believe it is somebody that goes through different numbers, monthly, weekly, whatever it may be. The officer believes that the family was involved with this individual and that they were really pushing this forward. The victim was obviously on board early on. We have since lost contact. The officer just on a typically beat just happens to see this individual last week. So we do believe that he's still in the area. He just doesn't have the same means of communication that we typically reach out to victims with. So I would be asking for a continuance on this matter. Your Honor, this is not going to be a continuance where I just simply send out another subpoena and we wait a month to show back up. The officer is present, has been sitting here all day knowing the victim's not here because he wants to show you, tell you that he is going to actively try to track this individual down.
All right, so, officer, are you here? Can you come up for a second? Your name, sir?
William Getz.
All right.
Easy.
Thank you, Officer Guest. Even if you find the alleged victim and serve him with the subpoena, because of his vagrant lifestyles, is what I'm hearing, how are you all confident he's going to be here for a trial?
My aim, ma'am, is to get in contact with him and hopefully through him, you'll get in contact with technicals that previously called us, get updated information, contact information, photos from them. So I can let the victim know, I can also let the family know, and know the prosecutor talked about, they were very supportive in the beginning. They called me multiple times in that first week or two, trying to make sure everything was going forward and they had everything necessary. It's just been maybe 6 weeks to 2 months since I've been able to make contact.
All right, thank you. All right, so the state is asking the court to continue this matter. Mr. Baker, what would you like to say?
Thank you, Your Honor. Your Honor, on behalf of Mr. Davis, the defense would object to the state's request for continuance and ask the court to consider a dismissal. If the court would be inclined to grant the state's request for continuance, we would then ask the court to consider giving Mr. Davis an OR bond. He is currently being held on a $20,000 bond. I don't recall if it's 10% or not. I believe that it is. Whatever it is the bond that he has not been able to make. Mr. Davis was arrested in January. He's been held in January, held since January. He has significant medical issues. He was actually residing in a nursing home at the time this alleged offense occurred due to his medical issues. He has severe kidney issues. He's been in the medical wing of the Justice Center, as far as I know, continuously since the day of his arrest. Certainly, he's been there every time that I've gone to visit him. So he does have significant medical issues. He is not going to have any contact with the prosecuting witness. This event occurred in a situation where they would not meet each other again. It started when Mr. Davis and the alleged victim encountered each other at a bus stop. Mr. Davis, we have no intention whatsoever to contact the prosecuting witness. The state has not been able to bring in here. Mr. Davis certainly doesn't need to find him anyway. He would go back to the nursing home if he was released. He does have strong family support. His niece has been in contact with me on several occasions during the pendency of this case. She is actually present on his behalf today. Unfortunately, what she can't do is post any kind of bond. At least that's what she tells me. She doesn't have the financial resources to do that. So we are going to ask the court to dismiss the case. We accept the trial today. The state's not ready to proceed. We're asking for a dismissal. If the court is inclined to grant the continuance, we would ask the court to consider a more on. I think electronic monitoring would be viable even at the nursing home. Not even be able to stay temporarily with its niece until the case is resolved. Thank you, Brother.
All right, thank you very much. State on bond.
On bond, Your Honor, obviously the victim's not present. We have attempted to get the victim here. My concern would be just the willingness to come back. And looking at the record, I don't have failure to appear, but the charges are very consistent, consecutive, and clustered. So I would just have concerns that he would appear. I understand where the defense is coming from with that request based on the state's inability at this time.
All right. The state's request for a continuance is granted for good cause. So I will continue the trial and we'll get a date is time gonna be waived? If we do, then I can put it out a little further. I'm considering the request for bond.
Thank you, Judge. I would certainly be willing to wait time if Mr. Davis has a chance to be released.
All right, now a couple of questions. Mr. Davis, you said was in a nursing home at the time of his arrest in January. We're, 3-4 months out. Is he still, is that still a viable alternative for him?
I was told that it was. Do you believe that it was Mr. Davis? Okay.
All right, I see someone in the back right. Can you stand up, ma'am? Who are you?
Stephanie, I'm his niece.
What's your last name?
Davis.
Okay, Stephanie Davis. All right, you're his niece?
Yes.
All right, and do you know the status of the nursing home situation?
Yeah, when he got arrested, he, left for that day, so he was able to go back, I can check and see if he still got his bed.
Okay, so you don't know. I see. Yeah, it's been a few months, so I'm not sure if that's a viable situation. If it was not, which nursing home are we talking about?
Garden Park.
Garden Park, okay. On Reading Road?
On Washington.
Oh, okay. And, if he cannot stay there, does he have a place to stay, Mr. Baker?
Judge, I had spoken with her today, and she had indicated to me that she would be willing to let Mr. Davis reside with her temporarily until the case is over, if he was not able to go back to the nursing home. Is that correct, Ms. Davis? So she would allow him to reside with her, but the intention would be for him to be able to go back to the nursing home. I think that's best. For him to do with no issues.
All right, Ms. Howard, can you do this form?
June 12th, I'm sorry.
That's fine.
June 12th? All right, June 12th, 10 a.m. for trial. All right, I'm going to grant Mr. Davis an OR bond with a stay away from the victim and EMD. And the thing is, we will release him, he can be released EMD to niece's home. And you can make arrangements for him to go back to the nursing home if that's a viable alternative. And then the EMD can be switched to there. But in order for him to be released, he'll be released to, what's your address, ma'am?
I'm currently moving right now, like this week. So
In 6 weeks?
No, this week.
Oh, this week?
Yes. So I will have to let him know my new address.
All right, but if he's released today, he has to be released today somewhere.
Okay. Then it will have to be
At the nursing home. Okay. Well, what I'm gonna do is I'm gonna leave the OR EMD. And then, obviously he won't be released unless, there is an EMD, address. So that'll be as quick as they can get it. As quick as I can have it. All right, and the trial date will be, June 12th, 10 a.m. Time wave?
Yes, ma'am.
Anything else?
No, Your Honor.
All right, thank you very much. Thank you. Elmore, nice.
Yeah.
That